Hi everyone, I'm Sabrina.
And I'm Jonathan, and we are the lawyers at Verity Law.
Today we will discuss how to deal with banks when receiving your inheritance.
For most people, receiving their inheritance fast is very important, as many costs immediately arise when their loved ones pass away. These include funeral costs and all expenses related to the deceased's home, such as the mortgage, property taxes, maintenance, and common expenses.
Exactly. Often, people will take the death certificate of their spouse or parent, go to the bank, and expect to receive their inheritance right then and there. Unfortunately, this won't work. The bank will tell them to get probate approval from the court before they can release the funds. The only accounts that can be inherited without probate are registered accounts such as TFSA, RSP, and RIF.
That's right. Also, the funds in the registered accounts would only be given to you if the deceased set you up as a designated beneficiary during their lifetime. If the deceased did not set that up, then those accounts also need to be probated. Of course, if you're not the beneficiary, then you can't access that account.
Now, as soon as you take the death certificate to the bank, they will immediately freeze all accounts that are not joint and that are not accounts with designated beneficiaries. This can have many unintended consequences, including canceling all mortgage monthly payments. Many people set up their routine expenses to be a pre-authorized payment from a specific account. When the bank receives notice that the deceased passed away, they will stop all withdrawals from these accounts, including any PAP set up during the deceased's lifetime.
Of course, this creates a big problem. Since the bank is no longer receiving the mortgage payments, the loan is technically in default. Under the Mortgages Act, they can sell the property within 15 days of default, although they will typically wait for 6 months.
This definitely creates a problem, as probate court typically takes 6 months to 1 year to approve a probate application. This is a race against the clock. You definitely want to receive probate approval before the bank start trying to sell the property. Thus, we always advise our clients to hire us for probate within 1 month of the deceased passing away.
In addition, since the accounts are frozen, they cannot be used to pay for any expenses of the deceased. While you can ask the bank to reimburse for legitimate expenses of the estate, banks will only allow for funeral costs and the estate administration tax.
Yes, other legitimate expenses like legal fees, accounting fees, property tax, common expenses, they must first be paid out of pocket by the executor or the beneficiary. After probate approval is granted, then they can be reimbursed from the estate funds.
As there are so many immediate upfront expenses after someone passes away, we always advise our will clients to leave some funds in registered accounts, joint accounts, or life insurance for the beneficiaries to access quickly. Even when you hire an efficient probate law firm like us, it would still take close to 6 months before you can dip into the estate funds.
Due to this delay and the upfront expenses, some people ask me if they can use the estate funds unofficially, meaning they have the online login of the deceased bank account. Can they just transfer the funds to reimburse for legitimate expenses like legal costs?
The answer is a big no. Banks have all the records showing when transfers are made, and the death certificate of the deceased would show when they died. If withdrawals were made after the date of death, then it is clear that this was done illegally. This will cause the court to lose confidence in the person who made the transfer, and they will likely never be approved for the executor position.
Exactly. Executors all have personal liability regarding how funds are transferred. If any estate funds were taken out improperly, then not only does the executor need to put those funds back, they can also be fined additional money. In the case of Walling and Walling in 2012, the court ruled that the executor must be fined 100K for misuse of funds on top of the funds that he had to put back. And in the case of Karupol and Shadok in 2023, the executor had to compensate the estate for the 174K of damages. And on top of that, the executor had to pay another 50K as punishment and another 50K for both parties' legal fees.
Yes, the consequences of misusing the estate funds is severe. This remains true whether the misuse happened before probate approval or after approval, but for illegitimate purposes.
Next, when notifying the bank of the deceased passing, selecting a branch is extremely important. This is because estate matters typically take 1 year to fully settle. This includes the time required to receive probate approval and getting the account settled after approval. During this whole year, you must constantly deal with the bank.
Yes. Now, when you first notified the branch, they will start an estate case for you. Then the bank system expects you to deal with that branch for the rest of the estate administration. So if you choose a branch that you do not like or that is very far from your house, for example, then this whole year would be a nightmare for you.
Of course, if you hired an in-state lawyer to handle this process for you, then they will do the communications with the banks. If you did this, then it's best to let the lawyer notify the bank so they can pick a branch that they routinely use. Having a suitable branch handle the estate matter makes the world of difference.
Now, when notifying the bank, you must bring the original death certificate. Since you can ask for as many copies as you want from the funeral home, this part is relatively easy. However, if the case has a will, be mindful that there is only one copy of the original will, which must be submitted to the court when you apply. This means that the bank absolutely cannot make any changes to the will, such as stamping it, writing on it, or even removing the staples or binding. To be safe, you should get your estate lawyer to make a certified true copy of the will and take that photocopy to the bank, not the original copy.
After an estate case is created, then you can ask for reimbursement of funeral expenses. You must provide a proper invoice issued by the funeral home. Then, you or your lawyer will ask the bank for the deceased date of death balance. It's crucial that this amount is as accurate and as updated as possible. When there is no will, the total amount of estate assets determines which beneficiaries gets what.
Yes. For example, when there is no will and the total estate value is under $350,000, then the married spouse gets all of the inheritance. When the estate value is over this, then the deceased children are also eligible beneficiaries. So knowing exactly how much money is in the estate is mandatory before you can submit a probate application.
Ensure that you get the correct amount of all accounts, including saving, checking, mortgage, and investments. Mortgage are the only debt that can be deducted against the total value of estate when calculating the total estate value mentioned earlier.
Investment accounts are held in a separate department at the bank. You must individually request the date of death balance from both the branch level and also from the investment department back office.
Next, you or your lawyer must ask the bank to pay for the estate administration taxes. For the first $50K, there is no tax, but for anything above this value, it is taxed at 1.5%.
Since earlier this year, courts have made it mandatory for this tax to be paid at the time of the probate application, not after. This means that either the executor or the beneficiary must pay this out of pocket and then get reimbursed later, or they must get the bank to issue a bank draft from the deceased's bank account.
Getting money from the bank before approval is a total headache. They require many legal documents and approvals from the back office. If the executor or beneficiary can shoulder this cost first, then a probate application can typically be submitted within 2 weeks. But if they must wait for the bank to issue the bank draft, then it could take around 1 to 2 months before an application can be submitted.
Exactly. So it really does depend on how fast you need the inheritance.
After the date of death balance and the probate taxes are provided, then your estate lawyer can prepare, notarize, and submit the probate application. In our firm, a probate with will application package takes around 1 week to prepare, and the court typically takes 3 to 6 months to approve it. A probate without the will takes around 2 to 3 weeks to prepare, and the court takes around 6 to 8 months to approve it.
After approval, the executor needs to take their ID and the approval document to the bank and open an estate account. The executor would be the only signing officer to this account.
Since COVID started, courts have stopped issuing original paper copies of the approval document unless specifically requested. Instead, courts send an email approval with the official digital approval documents attached.
If the bank rejects the printed copy you brought in, then you can ask your probate lawyer to forward the court approval email to the bank. Since it's an official email sent by the court, the banks must accept it.
Once the estate account is created, the bank will move all of the deceased money into this one account. This includes selling off all of the deceased investments and cashing those out.
Many clients prefer to directly inherit the investment accounts and not cash them out immediately, because sometimes selling investments in the year of death could result in losses, or it could result in huge tax consequences.
Unfortunately, this is not allowed. As the investments were made based on the deceased's income and other qualifications, it cannot be directly transferred to the beneficiaries. The bank will always cash them out and deposit them into the estate account.
If this is a concern for you, ensure you do proper estate and tax planning beforehand.
As executor, once you have full access to the estate account, you must maintain detailed records of all deposits and withdrawals from the account. This is especially the case if there are beneficiaries who are not the executor or if there are minor beneficiaries under 18 years old.
In the case of other beneficiaries, they can always ask the executor to show them a detailed deposit and withdrawal record of the estate account and the monthly bank statements. If there is any misuse of the funds, they can successfully sue the executor in court. However, if the executor maintained proper records and shows there was no misuse of the funds, then the beneficiaries can be dissuaded from taking any legal action.
When there is a minor, the children's lawyer will typically ask for detailed accounting of the estate account every year until the minor is 18 years old. You, as the executor, must take utmost caution with every deposit and withdrawal. I highly recommend hiring a estate law firm to help with this accounting, starting from the date you created the estate account.
All right, so let's do a summary.
Dealing with banks is a necessary and painful part of estate administration. Essentially, you must interact with them for close to a year in order to get your inheritance. This includes starting an estate case with them, getting the date of death balance, getting probate taxes paid, setting up an estate account, consolidating all accounts into the estate account, selling off all investments, and maintaining detailed accounting records.
Since every step must be done correctly to avoid personal liability, it is highly recommended that you hire an estate lawyer to help with this process. You do not need to give your lawyer access to the estate accounts or the funds. They can double-check all of your work and be paid on an hourly basis. Our office is especially popular amongst clients to act as this safeguard, even if we're not the executors to the estate.
For sure. That's all for today. We will see you in our next month's video.